Okay, so chapter 20. Everybody turn to chapter 20. In this chapter, we're going to discuss the transfer of title. Title is the word that means ownership. So in this chapter, we're going to describe the four methods of transfer, title transfer, and we're going to explain the process of the transfer of title of a deceased person's property. So title to real estate is talking about the ownership of the land. Alienation is the transfer of title to the parcel of real estate. This could be done during your life or after your death. It could be done voluntarily or involuntarily. At the time of death, it's voluntarily done through a will, your last will and testament, or involuntarily if no will is left, because the state will get it by the process of escheat if no heirs can be located. So we're going to go over all of that. So let's highlight on page 371. Title to real estate means the right to ownership of the land. And alienation is the transfer of title to a parcel of land. Voluntary alienation of title can be done by gift, sale, or exchange. Owners use some form of deed to convey that ownership during their lifetime, or by will to transfer voluntarily upon their death. And the transfer of ownership to or from the government is either done by dedication. You could give land to the government by dedicating it to them. This is not something you do after you die. This is when you're alive. You dedicate the land to the government for a greater public good like streets, schools, and parks. Often when a developer is developing a subdivision, as an example, they're creating a subdivision. Let's just say they're creating cul-de-sac street. They got a property. They're going to break it into 6 different houses that they're going to build on a cul-de-sac street. Do you keep that street that was built on your land private ownership that you'll then have to maintain forever? Or are you going to dedicate it to the municipality? Well, there's no benefit out of owning it, so dedicate it, that's giving it to the land, to the government for public use, such as streets, schools, and parks, and then they'll have to maintain it. When the government gives land to a private party, to an individual, it's done by public grants. They're granting the public the ownership. So that's how that's done. So let's do some highlights of voluntarily and involuntary alienation and what a partition proceeding is. And just let me know when you guys have all the highlights.
I'm good.
I'm good.
All right. Involuntary alienation can be done without the owner's consent. It's involuntary through the process of escheat, by eminent domain. If you don't pay your debts, like your taxes or mortgage, it can be done by foreclosure or by a court action called a partition proceeding or a suit to quiet title, or through adverse possession by easement by prescription. Some people refer to it as squatters' rights, but they don't fully understand how it works, and that ends up getting them to commit crimes. And then erosion, that's done by Mother Nature, wearing away the land by wind or water. We already highlighted the partition proceeding, right?
Yeah.
So here's a slide that explains an easement by prescription through adverse possession. Not a bad idea to snap a pic of this. So an easement by prescription through adverse possession, some people refer to it as squatters' rights, but squatters have no rights. That's when somebody breaks onto your property and they're using it against the owner's permission, but the owner doesn't take any action to get them removed from the property, and they're there for a long enough period of time using that property. They could claim ownership of it. So it's when you to perfect this type of an easement, though, you don't automatically become the owner of the property. You got to take the owner to court to perfect it with a suit for adverse possession or a suit to quiet title in order to perfect that claim of ownership to the land. Now, the use must be continuous, hostile, adverse to the owner's title, exclusive, and without the owner's permission. In addition, it has to be visible, open, and notoriously obvious that you're using their property. It can't be like, oh, I snuck on at night every now and then, nobody ever seen me, or I put an underground doggy fence I buried over there, so I've been using the land and you just didn't know it. That doesn't fly. So the prescriptive period in New Jersey, that's the amount of time that you have to use that property as prescribed by law, is 30 years for improved lands or 60 years for unimproved lands. Now, this law will be changed at some time in the future to the common law period of 20 years. They're going to do away with the 30-year period and the 60-year period. Problem came into play here is politicians like passing laws. And sometimes they do it just to see their own faces smiling and shake people's hands and get credit for doing something when they don't even bother to check if there's already a law that covers the topic. So sometimes politicians make too many laws that cover the same topic, and the laws are different. And that creates a conflict in the law. And when you got a conflict in the law, a judge cannot rule in anybody's favor. Because what is a judge's job? A judge's job is to interpret the law and pass judgment based on the law the way it is written. If a judge doesn't do that, and they make a ruling instead, they're creating a precedent that other judges will follow. So some people refer to this as legislating from the bench, creating de facto laws, even though the judge's job is not to create law, it's to interpret the law and enforce it. So when judges do this practice, which they should not be doing, sometimes they create problems for down the road. You can look no further than the whole abortion thing that happened last year, right? What was that, Roe versus Wade case? You had those politicians out there that were arguing, Republicans want to do away with long-standing protections for women's healthcare rights or whatever, as if abortion is a healthcare thing. They're wanting to do away with a long-standing law that's been in place for 50 years already that makes abortion legal. Really? There was a law that was ever passed like that? Who wrote it? Who voted on it? When was that passed? There is no such law that was ever written. You had one judge, one man, a judge, who legislated from the bench and ruled in a case where a woman claimed that she was raped in order to get an abortion. And he allowed it, and he set a precedent which became followed by all other legal rulings after that. It took all the way up until 2023 for somebody to take this matter up to the Supreme Court and argue against it, the fact that there was never a law established, even though you had politicians out there screaming that there was. But then again, politicians always do that so that they could make the other side look like bad guys, and the politicians themselves that were screaming that, the other side of the aisle is trying to do away with the laws that are longstanding. Well, there was never any laws, and they knew that. They could have passed a law that legalized it when they had the Congress, the Senate, and the presidency, all three. They could have passed the law and made it legal. How come politicians don't ever do that? They always like to spout at the mouth, but they never do it. Reason being is, what are they going to run on next election season? They always need a hot button issue that gets to some people's emotions, and they act like they're the champions of it, but yet they could care less. It's just a political reason that they could use as an argument to try to get people to give donations to them and to vote for them next political election season. So we have a situation here where there was, with that Roe versus Wade, where a judge made a decision creating a precedent. All other judges then follow that precedent until there's a law actually established. And the Supreme Court then ruled, and they made a decision which basically said they did not do away with any laws. They did away with a lower court's decision that set that precedent. It's because politicians never created a law, and that he improperly ruled on something that he should not have. He should have kicked it out of court until politicians made a law about it. So he did not do that. So it created a problem 50 years down the road. So all the Supreme Court did is say they kicked out his improper decision. And now they leave it up to the states to decide, unless the Congress passes a law, the Congress and the Senate, and then have a president sign off on it, passing a law, which they'll never do because, they may lose too many votes trying to do that. Because they never did that, now it's up to each state to create their own laws on whether they want to have abortion legal or not. So similar to the way that law was passed, New Jersey politicians passed several laws covering the prescriptive period. There's a 30-year law, a 60-year law, and then there was that common law period, which is always in effect, which was 20 years. So now we have all these laws in conflict with each other. So there was a court case that happened about 15 years ago. A judge, instead of ruling on it, kicked it back to the politicians because he noticed there was a conflict in the prescriptive period. And instead of ruling on it, he kicked it back to the politicians to do that. to correct the conflict in the law. We are 14 years later now, and New Jersey politicians, they know what they want to do. They're going to do away with the 30-year and the 60-year law and go with the 20-year. But 14 years later, they still haven't done it. They got it on the books. They've got the legislation. They just haven't voted on it. Why? Your guess is as good as mine. They want to pass a new gas tax. 30 days later, you got a new gas tax. They want to cure a problem that they caused 14 years later. It's still chugging along. Why aren't they voting on it? Get these people out of office. You're voting politicians in there that don't do a damn thing. So through the process of tacking, oh, by the way, so for exams, that 20-year period, not yet. So if you get the question on school exam about prescriptive periods, it's 30 years for improved lands and 60 years for unimproved lands for exam questions. When they ask you, what is the prescriptive period to perfect an easement by prescription? If it's improved lands, it got a building on it, 30 years. Unimproved woodlands, 60. That's what you should study for exams. Just be aware at some point in the future, if our politicians never get around to fixing the problem, it's going to become 20 years. Now, through the process of tacking, successors in interest, like a landlord or a tenant, an ancestor and an heir, or a seller and a buyer, they could add one person's time, they could tack on one person's time to that of another, combining them to reach the prescriptive period. That's what we refer to as tacking. When you combine someone's time who's only been there for a portion of that time with someone else's to reach that prescriptive period, that is possible, but they need to be successors in interest. A landlord and a tenant, an ancestor and an heir, seller and a buyer. Now, a way that an owner can prevent somebody from taking their land and perfecting that easement by prescription is they could take legal action against that adverse possessor, getting them removed from the land. They could cut off their direct access to it. This stops the continuous use and therefore resets the time clock. Or they could give them permission to use their land, because you can't claim an easement by prescription against an owner who gives you permission to use the land. What is the requirement? It has to be continuous, hostile, adverse to the owner's title, exclusive, and without the owner's approval. So if they give them permission, hey, you could use you could use my property till the end of the month and then you got to be out. Well, by saying that, they just reset that 30-year time clock, right? Or 60-year, whichever one it is. And an easement by prescription can never be claimed against publicly owned land. All right, if anybody's going to snap a picture, because I'm going to change the slide now. Everybody got it that wants to get it? Or you need a second? Does everybody got it that wants to get it, or do you need a second? All right. So let's do the highlights now. Adverse possession, easement by prescription. This is on page 373. Take the notes, write the highlights, and let me know when you're done with that. They do mention something else on here that you're not going to get on exam, but it is useful to know in real life. I've actually used this in several occasions, giving people advice on this. When the government puts so many restrictions in place on how you could use your land, you know, whether it is for environmental reasons or zoning reasons or whatever, if they put so many laws and restrictions in place on on how you could use your property, that they basically render your property useless, that you can't use it. An owner can claim something called inverse condemnation. You're through all of the red tape and government restrictions put in place, you rendered my property useless. So all of those burdens that you put on me without giving me compensation for it, I can now sue the city or the government to pay me for that devaluation, how they devalued my property through all their restrictions. That's called inverse condemnation. But you're not going to get that on exams. But it is useful enough. So let me know when you guys have all the highlights.
I got it.
All right. Anybody still writing or no?
I got it.
Just one more minute.
Okay.
Got it.
And this is going to be in chapter 6. When we get to chapter 6, we have to highlight this because that's where they also talk about an easement by prescription. Don't worry about highlighting it now. We'll have these highlights again, these slides again in chapter 6. So the easement by prescription, they're just going over those same notes, you know. It needs to be perfected by legal action being taken. Explaining what tacking is and how to perfect that easement with a legal claim. So how do we transfer a deceased person's property, the ownership of a deceased person's property? Well, title is a word that simply means ownership. There's no document in real estate called title. We transfer that ownership through deed. That's the document that's used to transfer one's title during their lifetime. Now, after they die, a title serves no purpose anymore. Titles are only used to transfer your ownership while you're alive. How do we transfer your ownership of property after you die? We do it through a last will and testament. That's the document that's used to transfer your property after you die. So a deed is how we transfer ownership while you're alive. A last will and testament is how we transfer it after death. So the title of the transfer of title by will is known as devise. You're going to devise your property to somebody you name in a will. That would be a devisee, the one that's going to receive it. So testate means that you died with a will. You're transferring your property by devise. A will, when you write a will, that will has no power until after you die. The will does not take effect until after you die. So transfer of title by descent takes effect when you die intestate. You didn't have a will. You didn't prepare a will. Who gets your stuff? Well, it's a form of involuntary alienation because you didn't specify who gets it. And because you didn't specify who gets it, who's going to get it? Well, your heirs, your natural blood relatives can lay claim to it. But if none of them step forward, the government will sell it at auction, use and then keep those proceeds in a fund for 1 year in which your relatives can step forward and claim ownership. And if they don't, then the state will take your property through the process known as escheat. That is explaining how escheat works. So you should consult an attorney about making your will and your legal options there. All right, so let's highlight. Intestate is without having left a will. This is on page 373. Down at the bottom, under transfer of a deceased person's property. Intestate, without having left a will. Testate has prepared a will. Probate is, or administration, is the legal process where a court determines who will inherit your property and what the assets of the estate are after all debts have been paid. And then either an executor or an executrix would be somebody you name in a will, or if you forgot to name somebody in a will, the court will appoint an administrator to manage your assets and ensure they're distributed according to your will, or if there was no will, to try to ensure and locate your relatives who may be able to claim it. Once again, here is that death term sheet we already went over. An heir is your natural blood relatives. They have a legal right to lay claim to your belongings of the blood relative who had died. You know, if you're an adopted child, you do have certain circumstances where you could claim to be an heir from your adopting parents. We're going to go over that in a moment. All right. So devise is the transfer of property, leaving it in a will to somebody specifically. You could devise your property to anybody. They don't need to be your heir or your blood relatives. They could be anybody. You could leave your property to a friend, to charity, to anybody. So the devisor is the one who makes the will, leaving that property to someone, and the devisee is the one that receives it, that was named in the will. Demise is a transfer of property by lease. It's not one of the death terms, but it is similar to devise, which is. So let's not confuse those two. That's why I got them here together. Testate means you prepared a will. Intestate means you did not. Testator is a man who makes a will, and a testatrix is a female who does. You notice only two genders? Don't go crazy now. All right. Probate is a court proceeding that determines who the natural heirs are and to confirm who the devisees of an estate are, no matter if you had a will or not, and what the assets are after all debts have been paid, mainly your taxes. Two things are certain in life: death and taxes. You're all going to die, and you all got to pay your taxes. Hell, you need to pay your taxes even after you die. Descent and distribution is the laws that determine who your natural heirs are and who gets your assets in the event you do die intestate. So we're going to go over that process in this chapter if you guys are curious, because you all noted that nobody here has a will. So who gets your stuff? Well, you got no say in it because you got no will. Until you make a will, if you If you get hit by a bus tomorrow or drop dead, only God will tell you that when that's going to happen, you know? So whenever that happens, it happens. Doesn't matter your age. You don't have to be old, but a lot of people, younger people, don't think about their mortality. You know, when they're young, they think they're invincible, but you never know. The laws of descent and distribution are the laws of the state that dictate who can get your stuff when you die. Now, and that's when you die intestate, without a will. And escheat is that process where the government gets it in the event you die intestate and no heirs lay claim to it. Then they'll sell your property at auction, keep the money in a fund for a year, 1 year. And if nobody lays claim to it, they keep it. The government gets your stuff, everything. The legacy is your personal property and assets that you leave behind that are not real estate. And the bequests are your wishes on who you wish to get it. Dower and courtesy are those New Jersey rights, those New Jersey ancient rights in which a wife, the dower is the right where the wife has certain interest upon her husband's death in any real estate that he owned during their marriage. Courtesy is the similar right that the husband has in the wife's estate upon her death that she owned during their marriage. New Jersey abolished the creation of any new dower or courtesy rights on May 28, 1980, a date you need to remember, because it didn't do away with any existing rights, dower or courtesy rights. If you were married before May 28, 1980, you have dower and courtesy rights still. But if you were married after May 28, 1980, New Jersey did away, they abolished the creation of any new dower or courtesy rights. Instead, now you and your spouse will only have the right of joint possession of the primary residence. Other properties you can own without your spouse having any interest in it. Did anybody go looking up missingmoney.com or unclaimedproperty.nj.gov to see if there were any funds there that available to you or your family members? I told you guys about these sites before lunch. No? Okay, good talk. Like talking to a wall. All right, so a last will and testament is an instrument made by an owner to voluntarily convey title to the owner's property after they die. We're highlighting these things. Party who makes a will is known as a testator if you're a man, testatrix if you're a female. The gift of real property by will is known as devise. You don't need to highlight right of election, guys, okay? So, but I will read it. In New Jersey, children can be disinherited. Your parents can write you out of the will, basically. But a surviving spouse is entitled to at least 1/3 of the estate. And the determination of the augmented estate is a complex calculation. In the case where a will does not provide that minimum statutory inheritance, your surviving spouse has the option of informing the court that rather than the lesser share that you wrote and left them in the will, they're going to opt instead for the higher amount that the minimum that you were required to leave them by law. See, if they don't make a claim for that, then they get whatever you left them. But they don't have to agree with it, because the law says that you can't write your spouse out of the will, and you can't leave them less than 1/3. And if you do, well, it is what it is. But your spouse can say, nah, I don't think so. Instead, I'm going to get more money out of it because you had to leave me at least 1/3. So I'm going to exercise my right of election, which is reserved only for a surviving spouse, to get 1/3 of everything. Okay. Now, a will differs from a deed in that your deed only transfers the ownership of the property while you're alive. And in order to be valid, a deed must be transferred, delivered and accepted during the lifetime of the grantor. If you signed a deed, but you never delivered it and it was never accepted by the buyer, transfer of ownership never took place. The deed never transferred that ownership. Now it goes according to your will, if you had one. This is in chapter 7. We're going to highlight this when we get to chapter 7. Here's an example of those words, like devise is the transfer of property by will upon death. So words that end in OR, we look at the word devise, that's the root word. That means a transfer of property by will upon death. We were to put an OR at the end of that, devisor, that's the one who's leaving the property in their will. That's the person who's giving whatever the root word is. If the word ends in EE, that's the person who's receiving whatever the root word is. So devisor is the one who's leaving the property by will. Devisee is the one who's receiving it. Grantor, you grant your ownership. So grantor is the owner of a property that's selling it or giving it away. They're granting their ownership to someone else. So the grantor is the one who's giving the ownership. The grantee is the buyer or the one receiving it. So on and so forth down the list. So legal requirements for making a will are as follows. A person must be of legal age and sound mind when they execute a will. That means when they signed it. The person drawing, the drawing of the will must be a voluntary act free from any undue influence by other people. Any person of sound mind who's at least 18 years of age or older can make a will devising their real property. All wills must be in writing to be valid. So a video will, an audio will, they're not legal in New Jersey. It has to be in writing. You could make them of you reading your written will, but the video will, you know, it plays no role. It's not legal in itself. You need to have that written will. So the general rule is that the will must be witnessed by two persons. A beneficiary may serve as a witness in New Jersey. And if the signature of the witnesses are notarized within 2 days, the probate proceedings can be simplified. A holographic will doesn't require any witnesses. That's when the will is completely handwritten. That's why before lunch I told you guys about this. I said, you guys can sit down on a napkin and write a will really quick, and that's legal in New Jersey because it's completely handwritten. You're deciding who's going to get your stuff. Now, under New Jersey estate planning law, holographic wills can be probated and will serve to ensure the testator's assets are bequeathed according to their testator's wishes. Now, for real property acquired by a married deceased person before May 28, 1980, what happened May 28, 1980? What was significant about that date on May 28, 1980? That's when New Jersey abolished the creation of any new dower or courtesy rights. So the surviving spouse is still entitled to a life estate of 1/2, not a third, a half interest of all the real estate, not just the primary residence, that are owned by the deceased, no matter what other provisions are made for in the will. So who gets your stuff if you die without a will? Let's read through the process of descent. Is anybody interested? Who gets your stuff if you die without a will? What the order of that is, how it works? Are you entitled to one of your relatives' assets if they died without a will? Do you want to know?
Yes, I want to know.
Well, then let's go over it. Title to real estate and personal property of a person who dies intestate passes to their heirs under the descent statutes. Now, your primary heirs are your spouse, civil partner or domestic partner, and close blood relatives. When children have been legally adopted, most states consider them to be heirs of the adopting parents, but not heirs of the ancestors of the adopting parents, like your aunts and uncles, your parents' brothers and sisters, or their parents, the grandparents. If you're adopted, you can't claim anything from them. If they wish to, they could leave it to you in a will, but if they die without a will, you can't claim to be a rightful heir because you're not a blood relative. Now, in most states, illegitimate children, okay, let's stop there for a second. That sounds pretty harsh. What's an illegitimate child? Anybody know? An illegitimate child is one who's born when your parents were not married. So if your parents weren't married when you were born, let's put this in Game of Thrones speak, maybe you could understand that a little better. You are the bastard child. Yeah, is that how they refer to it on Game of Thrones? So the illegitimate child inherits from the mother, but they do not inherit from the father. Unless that father admitted parentage in writing. That's pretty messed up. He is your actual true blood relative. But unless he admits or you could prove that your real father is actually your real father, you can't claim anything from him. Isn't that so crazy? So you can inherit from the father unless he admitted. You can't inherit from the father or his side of the family unless he admitted parentage in writing or it's been legally established in some other way, like through a blood test. And if your blood-related father actually adopts your child to make it legit, that child inherits like an adopted child would from the father, but not his side of the family. How crazy is that? You are actually a blood relative of your father, but you can't inherit from your father's brothers and sisters or his parents or any of the bloodline further up, because your parents were not married when you were born. These are some old laws, right? This is like some medieval age type laws that go way back, right? Well, until politicians actually decide they want to change these laws a little bit, that's the way that it works. So intestate real property is distributed according to the laws in the state in which the property is located. And New Jersey law of descent distribution provides that real property belonging to an individual who died intestate without a will is distributed in the following order that we see right here. So remember, this only comes into effect if you die without a will. Who gets your stuff? Well, your surviving spouse or partner becomes the sole heir if the descendant leaves no parents or children. If there's a child or children who are also the children of the surviving spouse, the spouse or partner receives the first $50,000, and then the rest is split between the estate between the child or children. If the descendant leaves parents and a spouse but no children, the spouse or partner receives the first $50,000 plus half the remaining estate. The rest goes to the parent or parents. If there's children who are not the children of the surviving spouse, that spouse or partner receives half the estate, the child or children the other half. And when no spouse or partner survives, children become sole natural heirs. Where there's neither a surviving spouse nor children or their own heirs, the estate first goes to parents, and failing that, to brothers and sisters or their heirs. Now, in default of any other natural heir, grandparents, aunts, uncles, and only first cousins could be considered heirs. Beyond that point, the entire estate goes to the state of New Jersey by escheat. So how does escheat work? Well, The state treasurer sells the property at a public sale, giving notice by publication in a newspaper in Trenton and a local newspaper in the county where the property is located. The proceeds of the sale are held in a fund for 1 year, and if no claims are made within a year to claim it, the state takes your money. So, if you want to see if there's any money that's owed to you or due to you, not just because somebody died or for estate or for estate, but it could be for many other reasons, for banking reasons. Now, for different reasons, money would stay in unclaimed property, these websites, for different periods of time. For the purpose of estate, it's 1 year. For banking, it's between 6 to 10 years for various reasons that you could find things in here. I tell people I had a girl in class one time. She used to work at Hot Topic, like in the Woodbridge Mall. And her boss never gave her her final check. Instead, he forwarded it to the state. She was taking this real estate class. She looked it up and she found out that her last paycheck, the state had it. She claimed it and she got it a couple of years later. So you never know what's in here. You may have something owed to you. If you did not check yet, you guys may want to check now. Unclaimedproperty.nj.gov or missingmoney.com. New Jersey no longer participates in missingmoney.com, though. And that concludes chapter 20. Let's do the key terms to review for chapter 20. And there's only one of them. Next, the letter L, I want you to write, after it says one who can inherit, I want you to write blood relative after that. Next is number 5, where it says executor. I want you to write / executrix, EXECUTRIX, executrix. Next to executor. That's next to number 5. And next to number 12, where it says testator, I want you to write testatrix. Everybody got those 3 adjustments?
Got it.
Okay, so let's do the key terms to review. Person named by the state to administer a descendant's will. This is when you don't name somebody in a will, and the judge would order somebody to manage your estate. What do we call that person? Who's appointed by the court to do it.
I want to say last will.
Now, what do you call the person? The person who's named by the state to administer the descendant's will.
Executor.
It's an administrator. An executor or executrix is somebody that you would name in the will. So an administrator is somebody who's appointed by the court when you never named an executor or an executrix. So one is A. A court proceeding to establish the validity of a will. What do we call that whole court process, that whole court proceeding that determines who the heirs of the estate are, or what the assets of the estate are after all debts have been paid?
Testate.
Probate. 10 is B. Probate is the court proceeding that establishes the validity of a will. So 10 is B. Title acquired by usage. When you simply use somebody's property, you could gain title to it. Some people refer to it as squatters' rights. It's adverse possession. Adverse possession, 2 is C. A person named in a will to administer a descendant's estate. What do you call somebody who you named in a will to do that? When the court appoints somebody, it's called an administrator, but when you name somebody in the will, they're called a
Executor.
executor or executrix if they're female. 5 is D. Transfer of title without the grantor's consent. It's without their permission. Transfer of title without their permission.
Involuntary alienation.
Involuntary alienation, 8 is E, correct. Without having made a will. Without having made a will, what do we call that?
Intestate.
Yes, intestate, 7 is F. What do you call the person who makes a will? They're a testator or a testatrix. 12 is G. Document disposing of property after one's death.
Voluntary alienation.
No, what do you call the document to transfer one's property after they die?
Last will and testament.
The last will and testament, or the will. 9 is H. What do you call it when you made a will? How did you die if you died with a will?
An heir. A descent.
Testate. You died testate. You testate means you died with a will. Intestate means you died without a will. So, having made a will, 11 is I. Testate. Acquiring of property by natural heirs. What do you call the people in your family? Your descendants. So, acquiring of property by natural heirs is the state's law, the rules, that whole set of rules that I just read over at the end there, called descent and distribution. So it's by descent, descent. So 3 is J. One who receives real property through a will.
Heir.
Okay, and the heir that you're leaving the property, an heir could receive property through a will. But what do you call it when you name somebody to get property through a will? It's a different name.
Testator.
Devisee.
The devisee. So 4 is K. See, an heir is your natural blood relative who could lay claim to it, right? But the person you specifically leave it to is a devisee. That's somebody you specifically wrote in a will to get your stuff. So that was 4 was K. One who can inherit the blood relative, well, which I just told you. What is it?
Descent.
Oh no, I just told you. We just spoke about it. What do you call somebody?
Oh, advisee.
An heir. An heir. They're the natural blood relatives who can claim owner or who can claim rights to your stuff when you die without a will. So that would be an heir. 6 is L. A transfer of title with the grantor's consent. So transfer of ownership with your permission.
Voluntarily alienation.
It's voluntary alienation. 13 is M. And that concludes the key terms to review for chapter 20. So we're done with chapter 20.